First edition of Law Made Simple for 2019. Let me take the opportunity to wish all of you viewers and listeners a healthy, happy, and productive 2019. And hopefully we can keep this program going as we have done in the last many years. I'm not too sure. We are now closing in on 10 years since this program has been going consistently. And let us keep it up and try to make the most of it. It's all about public legal education. And remember, if you have any questions or comments, you can share it on Facebook or the various platforms, especially any questions you may have, any clarifications you may wish to seek. This program, if you recall, the last program we did for 2018 focused almost exclusively on pensions. We ended the year on pensions, and it is my hope to begin the year on pensions, particularly as we have a live issue now that does not seem to go away, and certainly by all indications will not be going away in a hurry. And that issue relates to pension for public officers. And what I started doing on the last occasion is to put in it the issue of pensions in its historical perspective and looking at the various sides of the legal arguments and the legal positions, not necessarily the emotions of it, but the pure law, what the Constitution says, what the law says. Unfortunately, I came from a different location this afternoon and don't have all my material before me, but I think I'm fairly versed enough to be able to share with you as much as I can with respect to the various positions on this very important issue of pensions. And I will seek to recap, given that the last program was since before Christmas. I will seek to recap some of the salient points made in that program, which provides the overview for the present issue relating to pensions. So don't forget, if you have any questions, any issues of clarification which you may seek, then feel free to shoot your questions via Facebook or the other platforms. Before I begin in earnest on pensions, though, let me take this opportunity, given it's the first opportunity I have since December, to extend condolences to the family out there of Sir Fenton Ramsahoy, Queen's Counsel, Senior Counsel. He passed away on December 27th, 2018, and he was buried a few days ago this year in Barbados. But I think I should use the opportunity to salute Sir Fenton, who died at the age of 89. And he was one of the brilliant minds. I wouldn't venture to say most brilliant mind, but I would certainly say that he was among the brilliant minds, brilliant legal minds of this region. And you may not have heard much about him necessarily in the public arena. He was in the courtroom arena, certainly, So Fenton died with his boots on at the age of 89. And what I would wish to highlight about his service, first and foremost, he served the legal profession for 65 years. And I believe that has to be a record somewhere in the Commonwealth. And I'm not speaking about dying in bed after 65 years of service and the last 10 years of illness laid up in bed. Literally, he died with his boots on. Only recently, he was appearing in court and a very active member of the bar. 65 years is no easy feat. And we have our own Cosmos St. Bernard locally in Grenada, who is now in his 90s. Cosmo probably is about 94 by now, and he is also past 60 years at the bar, approaching 65 if he has not yet reached 65, and he is still in active practice with some limitations, but goes to office on a daily basis. And we have to salute folks who have persevered over the years and served for these extended periods. Sir Fenton actually appeared in court, and another feature, apart from his court appearances over those 65 years consistently, but I must also say that he was probably, arguably, the Caribbean advocate who made the most appearances before the Judicial Committee of the Privy Council. I know Sir Joseph Archibald, Dr. Joseph Archibald from the BVI made several appearances. Dr. Archibald passed away about 3 years ago, within the last 3-4 years. And Dr. Archibald, one-time president of the OECS bar, I always recall him making the point up to 2014 when he passed away that Sir Fenton was the advocate who made the most appearances at the Privy Council. And even after Dr. Archibald passed away, Sir Fenton continued to appear before the Privy Council. So it is really an historic achievement, a landmark. He has left his legacy in so many different ways. He was a formidable advocate. Initially Guyanese by birth. In fact, he served as Attorney General in Guyana between the years 1961 and 64, when my good friend George was just in his diapers. He was very active in his in court as an Attorney General in Guyana. And he also served as a member of Parliament in Guyana between the years 1961 and 1973. So he has served Guyana well. He is a son of the soil, but even more so, he has served the region well. And he has done many of the cases out of Trinidad and Tobago that eventually found their way to the Privy Council in the United Kingdom. He has also made several appearances before the Caribbean Court of Justice in its appellate jurisdiction on behalf of Guyana, cases emerging from Guyana. So well done, Sir Fenton. You have certainly served the region well. And OGBA, that's the Organization of Commonwealth Caribbean States, of which I'm the president, has saluted you, has already saluted you, and I just take this opportunity in this program to highlight that outstanding achievement that he has managed to accomplish before his passing on December 27th. So let's move straight on to the Constitution. I must say, in fact, to that I had the privilege of appearing on the other side of Sir Fenton because he was also involved. He appeared throughout the OECS and he appeared in the Commission of Inquiry case back, it would have been 2006, 2007. He was counsel for the Commission of Inquiry, the Cheltenham Commission of Inquiry then. And there was litigation that emerged from that matter, and he was actively involved in that litigation. I was also, and the matter was settled through meetings when it went up to the Court of Appeal. So he's actually appeared in Grenada. I omitted to make that point. Yes, so far for Sir Fenton, we move now to the pension issue. And just let me raise some of the salient points that I raised in the last discussion on this issue, which unfortunately we were not able to complete because of time constraints. But the first point that I wish to make is that the Constitution of Grenada makes provision in 3 separate sections for pensions, and they all relate to pensions for public officers, and that relates to the sections are section 84(8) of the Constitution, section 92 and section 93 of the Constitution, which sections I believe I would go through in full to put the present debate into context. So that's the first point. The second point is that we also have certain laws. Apart from the Constitution, we have certain ordinary laws relating to pensions. And those laws date back to 1958, the 1958 Pensions Act. And subsequently, we have had several interventions and amendments to the Pensions Act. And among them, we had People's Laws number 14 of 1983, People's Laws number 24 of 1983 that affected the Pensions Act. And then we had the Act number 1 of 1985, and that is the act that validated laws passed during the PRG when Parliament was not functional in the Westminster model as we know it, and when the Constitution was suspended. And so we have had these interventions in relation to pensions, all relevant to the debate today. We have also had several cases on pensions, and probably the most discussed, that though there are several others, but the most discussed are you have Donovan and the AG, the very first in line, dating back to 1987, 1988 or thereabouts. You have Duncan and the AG, dating back to the early 90s. And then you have McQueen and the Attorney General, which dates back to the later 1990s or thereabouts. It was subsequent to Duncan. And those three cases that you hear much about relate specifically to Section 84(8) of the Constitution, which we would come to. And then you have another case subsequent to these three cases that I mentioned, and that's the Herman Armstrong case of 2009 or thereabouts, and that case relates to Section 92 of the Constitution. So we try to not put all these cases in perspective, and what I will try to do is to highlight what the various positions, in a dispassionate and objective way as possible, the different positions that are floating out there with respect to the legal interpretation of matters. And the very important point that I made in the last session that I wish to make again, because that point is not highlighted probably as it should, and it has gotten lost in the emotional nature the debates have taken, and that is the setting up of the National Insurance Scheme in 1983 under the PRG, April 4th, 1983. And that act, as I mentioned then, that act was aimed to bring relief to working people throughout the length of Grenada, Carriacou, and Petit Martinique. Some form of social security to ensure that when people are sick, when they become invalids, when they are no longer able to work and they have reached the quote-unquote retirement age, that benefits would come to them. And interestingly, it was only recently that, in fact, after we had this program, the last program, I believe, I heard the governor of the Eastern Caribbean Central Bank, our own Timothy Antoine, describe the NIS in very glowing terms, and the effect of the point that he made is that it's one of the greatest interventions, and I'm just praising what he made on behalf of working people in this country, probably in history. And it was interesting to hear that point coming from him, because I've heard the point made otherwise, but that point has not been highlighted in the way that probably it should. And the NIS was set up basically to provide a safety network for people, some form of social security for all workers, not some workers, but for all workers, and even for the self-employed. And you then had, under the NIS, you can get things like maternity leave, sickness benefits, invalidity benefits, pension benefits, survivors benefits, benefits in all different forms that would naturally impact positively on employees. Because as we do know, insurance is extremely important. We only understand the value of insurance when we have a loss. In fact, when we don't have a loss and we pay insurance, we curse the insurance for taking all the money. And if we can only drift back to 2004 at the time of Ivan, I know of several persons who had stopped paying insurance, even the year of Ivan, because they thought, listen, I just pay insurance year after year, nothing is happening, and therefore I'm throwing away my money and fattening the pocket of the insurance company. Same thing with health. You may be enjoying a life of health and then suddenly have an emergency. And that's when health insurance becomes important. In times of hurricane, when your house is destroyed, then your insurance against natural disasters, these things become extremely important. And just so with insurance, when it comes to national insurance and sickness and invalidity and pensions, these things become extremely important. And the NIS law, if we note, the Act, the People's Law, setting up the NIS, and also the People's Law that made alterations to the 1958 pension arrangements ought to be seen in the context based on developments that unfolded after. So what we saw is that one, in 1958, the 1958 Pensions Act made provision for pensions for public officers. And the pension here included a gratuity and pension. And those were for established workers. The Act itself stated that pension was not an absolute right, and the governor at the time, because as you know, we were a colony in 1958, not yet even having achieved internal self-government, which was done some 9 years after, in 1967. But the governor at the time can basically, for whatever reason, can deny you pension. And you will see the significance of that when we come to the provisions of the Constitution. Now, in 1974, as we all know, we became an independent nation, and we had a constitution in 1974. And at the time of the new constitution in 1974, the Pensions Act, in effect for public officers, was the 1958 Pensions Act. Fast forward to 1979, there was a revolution, and as with all revolutions, there was a suspension of the Constitution. And as I've mentioned before, whenever there's a revolution anywhere in the world, then you have a suspension of the existing Constitution, for the simple reason that the revolution comes into power inconsistent with the means provided by the Constitution. So there is usually a suspension of the Constitution. In fact, in relation to the PRG, in July 1983, a Constitution Reform Commission led by Senior Counsel Alan Alexander from the Republic of Trinidad and Tobago was set up to look at a new constitution for Grenada, one that focused on people's participatory democracy, as the position of the PRG on Westminster democracy was well known, that it was a 5-second democracy every 5 years that did not involve the people except in the voting process to elect a new government, but that in between those 5 years, there was never any meaningful participation in the affairs of the country. And a new constitution would look at the issue of people's participation as the center of the process. And in an early people's law, in fact, among the 10 people's laws, in the very early days of the revolution, People's Law number 9, I believe, it guaranteed pensions and pension rights and the protection of the existing pensions of workers. And so that was 1979. Fast forward 1983, when the NIS was set up. And the aim here, it became a contributory pension scheme with workers and employees making a contribution to the pension. And the whole idea was that you will have now an entity, a single entity that dealt with all pensions for everybody. And the aim was to expand the base of pensions beyond public workers, to make every single Grenadian worker and self-employed person entitled to a pension upon retirement. And that is important to understand in the whole debate. That was the aim, the objective of the PRG, to expand pensions beyond public workers. And remember what the 1958 Pensions Act established: pensions for established workers within the service. What that meant was the category of workers known as unestablished workers, who form a significant number within the public service. They were not entitled to pension, the unestablished workers. So what the NIS did is to make everybody, including those self-employed and those professionals employed with nobody but themselves, to give them an opportunity to contribute towards the NIS and earn a pension at the age of retirement, which was 60 years. So that was the noble objective then. And therefore, what the PRG set out to do is to place all pensions in the hands of that social security scheme, NIS. Because, as you know, you don't want pensions to be based on how the consolidated fund goes. You know, with NIS, and so you have all the professionals, you have investment of monies, you have the actuaries, and all the experts managing that pension fund, investing that pension fund, making the pension fund make more money. So you take it out, you remove it from the hands of a government-run and controlled scheme to one in which the NIS will oversee. Now, what you're not hearing much in the debate also, quite apart from what the noble objective of NIS was and the intent to expand the base of pensions, is that in the NIS Act, which was passed that it made provision in sections 45 and 46, or 46 and 47, or thereabouts, between sections 45 and 47 of that act, to make or empowering the minister responsible for social security to make special provisions for public officers. Because, of course, those persons, that category, public officers, will have already been receiving a pension. So the whole objective was not to take away anybody's pension rights, but to expand those pension rights and to make special provision through the NIS Act for public officers, in other words, streamline it, recognizing that they were already receiving pensions and there were others who received no pension at all. So all of that was to be taken into consideration. And essentially, the PRG established through its People's Laws, number 14. There were two People's Laws, 14 and 24. 114 established the NIS, well, it was 14 and 24. One established the NIS, and the other established what is referred to as a cutoff point for pensions, the kind of pension you would receive. So, for example, those persons who entered the service up to the 3rd or the 4th of April, 1983, will receive what we would call, for better, for want of a better expression, a 1958 pension. And those who entered post April 4th, 1983, when the NIS was set up, will receive an NIS pension. In other words, that simply was the intent of the scheme. And post-84, post-April 4th, 1983, April 4th, 1983, will see not only public officers being entitled to pensions. So in other words, not because you're working with the government alone that you will be entitled, but wherever you are in the private sector, if you're a farmer, a mechanic, a body workman, just name it, you become entitled to a pension post April 4th, 1983. So post April 4th, 1983, everyone becomes entitled to a pension. And through the mechanism of sections 45 to 47 of the NIS Act, the minister will then streamline the public workers' pensions, recognizing that they already got a pension. So the intention was to enhance and bring the NIS pension in line with what the public workers would have been receiving. So that was the authority given to the minister. Now remember, a lot of these things up to, in fact, People's Law number 24 was passed in September 1983. And then in October 1983, the PRG imploded. You had the US invasion, and the revolution becomes history. So there was no time from a PRG's perspective to implement the vision created through the NIS with respect to pensions. So I say all of this to say that the PRG did not interfere with pensions in an adverse or negative way, but actually expanded pensions, expanded the base of pensions with the intent that the entire country, all workers, will benefit. So, fast forward now to 1985. 1985. Remember, after the invasion in October 1983, then the Governor General had essentially executive and legislative authority until the return to elections in 1984. So like the PRG, you had 79 to 83 PRG. PRG exercised executive and legislative authority in the absence of a parliament. Post-invasion 83, an interim committee is set up, and the Governor General exercises both executive and legislative authority. So the Governor General issued proclamations. The PRG made people's laws. Come general elections, the first since the revolution and the first since 1976, those elections were held in December 1984. And with the new parliament now coming into being, the return of Westminster democracy, then Parliament, one of the first acts of Parliament in 1985 was the, what you call, in simple terms, the Validation Act, Act number 1 of 1985. The very first act, which was to validate laws passed by the PRG and to validate proclamations made by the Governor General post October 83. So they become integrated as part of laws now having the blessings of Parliament. And remember, under the Constitution, Parliament, Section 38, Parliament makes laws for the peace, order, and good government of the country. And therefore, those people's laws, those proclamations under Act 1 of 1985 became formally laws endorsed by Parliament. That included People's Laws number 14 and 24 of 1983. The laws that set up the NIS and the laws that brought into being the new pension arrangements as perceived by the PRG. If you enter the service before April 4th, 1983, you get a pension under the 1958 laws. If you enter post 83, you get an NIS pension. So therefore, what went wrong? With the PRG introducing all of these measures and no longer in existence to follow through on those measures, then there was a dropping of the ball. Clearly. Because pensions is something that you make provisions for the future. And you put your systems in place to ensure that in the future, when pensions become payable, then you can pay it. What happened is that nothing was done under sections 45, 46, 47 to address the issue as the NIS Act allowed it, to address the issue of pensions for public officers to bring it in line with the National Insurance Scheme formula for pensions. So nothing was done. And then, because you only become entitled to a pension after April 4th, 1983, then remember, if you join after April 4th, 1983, you had to work for 20-something years before you get your pension. So everybody falling asleep, nothing being done. Then you had the first set of persons who were employed post-1983 by the government retiring, including Homeland Armstrong, as we know the Homeland Armstrong case. And the argument there is you entered the service post-1983, and therefore you are entitled post-April 4th, 1983, and therefore you are entitled to an NIS pension. For those who came in up to April 4th, 1983, you are entitled to a 1958 pension. So we see the first set of retirees starting from about 2009, after making the 26 years of service, beginning to retire. And then you have the case now, the Homeland Armstrong case. And essentially what that case decided is that Homeland Armstrong was entitled to a 1958 pension. However, the NIS pensions that she received, then that should be deducted because she could not be entitled to two pensions. The intent was not to establish two pensions. That in itself raised further legal issues. So that case I refer to as the Section 92 of the Constitution case. Section 92 of the Constitution. The other cases, Donovan, Duncan, and McQueen, I group in the same category and refer to them as the 84-8 cases of the Constitution. They deal with a completely different point to the Homeland Armstrong case. Now, what point? And it's at this point I will introduce the whole issue of the relevant sections that we need to understand. As I said at the beginning, there are three sections of the Constitution that deal with pensions. And I would read each section in its entirety so we can get the full picture. What does 84.8 say? That's the Donovan, Duncan, and McQueen cases. It says every officer who is required to retire on abolition of his office or on abolition of his office or for the purpose of reorganization of his ministry or department shall be entitled to pension and retiring benefits as if he had attained the compulsory retirement age. Let's break it down now. If you are required to retire, one, because your office is being abolished, or two, for the purpose of reorganization of your ministry or department, then 84.8 says You are entitled to pension and retiring benefits as if you had attained the compulsory retirement age. So let's just look at these three cases quickly to see how they fit in to 84.8. Donovan, the very first case. In Donovan's case, the government of the day passed a retrenchment act. It was referred to as, it was one of the first major retrenchments within the public service, and even then referred to as a golden handshake. And what that act did, in a sense, was to say how your pensions upon your retrenchment, how your pension was to be calculated for each individual. And those would depend on your years of service. Put simply, the longer you work, the higher your pension entitlement. If I may strip it of all the fat and go straight to the lean. The longer you work, the higher your pension entitlements. However, and Donovan was one who, in fact, he had worked for a significant period within the public service. But in his first case, he says, listen, I am entitled. Once you abolishing my office or you reorganizing my department, I am entitled to a pension to be paid as if I had reached the compulsory retirement age. In other words, as if I am 60. So you're retrenching me when I'm 40, pay me as though I'm retiring at 60. You're retrenching me at 50, pay me as if I'm retiring at 60. You're retrenching me at 35, pay me as though I am retiring at 60. So my years of service, in a sense, would not necessarily dictate how you calculate my pensions based on those years of service. You have to calculate it as though I have reached the compulsory retirement age. That was what Donovan. So Donovan was formally retrenched from the service. And he challenged what the Retrenchment Act passed by Parliament said that he should be paid, and say, pay me, in effect, as though I had reached the retirement age. Duncan and the Attorney General, different factual scenario, but same principle. Duncan was an 84.8 case. And in the case of Duncan, Duncan was sent home on leave for the purpose of the reorganization of his department in the Ministry of Finance. His leave expired. In other words, all his leave was used up, and he was asked to remain home. Still, his leave having been used up because his department was being reorganized. And essentially what Duncan says, hey, I'm not on leave. You have indicated that you are reorganizing my department. Effectively, you have retired me. Pay me as though I've reached the compulsory retirement age of 60. I might be in my 30s, but I'm entitled to be paid a pension as though I had reached the compulsory retirement age. That was Duncan. McQueen and by the way, both Donovan and Duncan were pre-April 1983 employees. Not post. They were pre-April 1983. And that's why, again, the retrenchment, 84.8 creates an independent right, as the courts have held. And in the case of McQueen, McQueen was the only, in those three cases, the post April 4th, 1983 appointment to the service. And in the case of McQueen, he was appointed in 1984, and his post within the labor local government department was abolished. And McQueen says, pay me as though I have reached the compulsory retirement age. I am entitled to a pension as though I have reached the compulsory retirement age, because once it deals with one, abolition of my post, or two, with the reorganization of my ministry or department, Section 84(8) of the Constitution, the supreme law, says I should be paid as though I have reached the compulsory retirement age. Now, so in McQueen's case in particular, because he entered the service after 1983, April 4th, he actually entered, I think, September 84, or thereabout, sometime in September, certainly, 84. The issue then became one of whether or not he would have been entitled to the pension that he was claiming. Because remember, if you come into the service after 1983, April 4th, 1983, based on People's Law number 14, is that you are entitled to an NIS pension. And essentially what the Court of Appeal, and I want to point out, in all of these three cases, all three litigants lost at the High Court. All three litigants, before three separate judges, lost at the High Court. And the High Court decisions were reversed at the Court of Appeal. And the essence of that point when it comes to 84(8) is that 84(8) is entrenched in our Constitution. Is entrenched in our Constitution. It actually creates an independent right with respect to public officers. And it says what it says. If you abolish my post, pay me as though I've reached the compulsory retirement age. If you reorganize my ministry or department, and therefore you retire in me, pay me as though I've reached the compulsory retirement age. That is what those cases were about. So the Donovan, Duncan, McQueen cases fall in a particular category, different from the Hummelin Armstrong case. And in fact, when the court analyzed the people's laws, in McQueen's case, because McQueen was a 1984 appointment, basically what it says is that even ordinary act of parliament or the people's laws, which were validated subsequently by Act 1 of 1985, when the new parliament came into being, the validation laws. So in other words, people's laws and Governor General's proclamations now become laws of parliament by virtue of Act 1 of 1985. And essentially what the court says is that these ordinary laws, Act 1 of 85, even though it validated, but the Constitution is the supreme law, and therefore you cannot amend the Constitution by ordinary legislation. 84(8) therefore applied with respect to the calculation of the benefits of those respective public officers. And by calculation here, I mean pay me as though I reached the compulsory retirement age. Let me now look at 92. And I will read 92 in its entirety and present what are the different sides of the argument in this debate. 92 of the Constitution, as I say, 92 and 93 come under the general rubric of pensions. And it addresses pension laws and protection of pension rights. What does 92 say? 92.1 says, the law to be applied with respect to any pensions, benefits, that were granted to any person before this section comes into the operation. And you know, before this section comes into operation, this section will come into the operation with the coming into being of the Constitution. This is section 92 of the Constitution we're referring to. So the law to be applied with respect to any pension benefits that were granted to any person before this section comes into the operation shall be the law that was in force at the date on which those benefits were granted, or any law in force at a later date that is not less favorable to that person. So essentially, what does 92.1 say? Translated into our own local situation is that at the time the Constitution came into force in 1974, the 1958 Pensions Act was the applicable law for pensions. And essentially, the benefits that are granted under the 1958 legislation will be the applicable benefits for a public officer, save and except that at some later date, some other act is passed that is not less favorable to that person, the person who is entitled to the benefits. So from that sense, it protects existing pension rights. That's one, section 1. 92.2, what does it say? 2, it says the law to be applied with respect to any pension benefits, not being benefits to which subsection 1 of this section applies, shall, 1, and that's 2 Roman numeral A, 2A, insofar as those benefits are wholly in respect of a period of service as a judge or public officer that commenced before the date upon which